Good morning, everybody. Happy Friday, and welcome to our regular feature for Feature Fridays. And today we have an extra special guest. Valerie is a member of our team. We are so grateful to have her as a part of our group. And not only is Val a broker, she also has specialty knowledge and so much experience in wills, in estates, and everything to do with that you need to know to protect your clients and really add that value. So Val, why don't you do a quick intro for yourself and take us away this morning?
Well, thanks. So I've been in the real estate business for over 20 years, and throughout my career, just organically, I was able to, and just really blessed to be helping families with estates. And through that, I found a lot of disconnects. And so I tried to bridge that gap with education, certification, and that's where I am today.
Amazing. So we're going to go through our presentation this morning. If you guys have questions, you can throw them in the chat. Wait till the end. We will have time to do a quick Q&A, but we want to make sure we can get through everything this morning. And thank you so much for taking the time with us this morning. This is great. All right, if you want to share your screen, let's dive right in.
Let's give it a try, see how we do here. Start the broadcast, and let's see how we do. Oh, I've got a circle. Let's try this one. Sorry, guys.
That's okay. It wouldn't be a Zoom meeting if technology didn't give us a little bit of a hiccup, right?
Okay, yes, there we go. Okay, almost there. Everybody see that?
We can.
Yes, awesome, awesome. Okay, well, good morning, everybody. Thank you for joining me on Friday the 13th to discuss estates. Just a brief kind of, this is what's going to happen today. Estate administration is rarely straightforward, as some of you know, especially when it comes down to closing out an estate. Whether you're acting as an executor for the first time, or a seasoned real estate professional assisting families through these transitions, you must know the process can be complex, emotional, and often time sensitive. So today I kind of designed it to bridge the gap between legal responsibilities and a practical execution. We'll explore what it takes to successfully close an estate, from securing and preparing the property for sale, to understanding the probate requirements, asset distribution, and managing timelines, which is really crucial. And then we'll highlight some pitfalls and clarify some professional roles and provide tools to ensure that the process is handled with clarity, integrity, and respect for all of those involved. Okay, so thanks again, and we're just going to dive in. Today, we're going to be covering a number of areas: the role of the CEA, the role of the executor, the role of the power of attorney, buying and selling of estates, touching on taxation, and just some final thoughts. Now, just before I begin, I just wanted to let you know that there are 15 real estate agents in Toronto and 3 in York Region that have been certified by the Canadian Institute of Certified Executor Advisors. The institute is CICEA.ca. So not a lot of us out there. So the role of the CEA is we're professional trained to guide executors through the complexities of estate settlement. This is kind of what an estate might encompass. As you see, any given estate, the executor may need to contact as many as 17 professionals in the estate closure process. This is usually a year-long task, and it's often referred to as the executor's year. In my experience, I haven't touched on all 17 in one estate, which I'm very grateful for. But I've, of course, accountants, appraisers, banks. Thank goodness, no bankruptcy, no corporate executors, credit unions, financial, funeral directors, of course, lawyers, life insurance. I've had the need to just sort of bring in a little bit of support for a couple of my families. Mortgage lenders, of course, no paralegals. I've mostly dealt with lawyers, planned giving officers for sure, as it's part of the will, insurance brokers, and of course myself and all of you guys. So, okay. So the role of the CEA, basically the key duties is have a comprehensive understanding of executor duties. The executor duties we're going to go through so you have a better understanding. Assist with taxation matters. Again, we're going to go through a little bit of that. Managing digital assets. And just a note, digital assets are things like your online banking, your investing, your trading, your websites, your social media, all of that are your digital assets. Handling complex estates. I'm just going to, some of you probably, like how complex can an estate be? And you might have that question. So I was able to pull off a case study. And I'm just going to quickly read it so you have an understanding of everything that could potentially be involved in an estate. Okay, so just a brief overview. Marion Hamilton, a wealthy widow, passed away at 87 in Toronto, leaving an estate valued at $12 million. Her estate included a primary residence in Rosedale, 2 income properties in Toronto, a cottage in Muskoka, an art collection, some of which the origins are unclear, jewelry, antiques, and designer furniture, several investment accounts in a private family trust, a business with her late husband's name still attached, digital assets, which included cryptocurrency, estranged adult children, and estranged minor children. So the executor then had to go in and sort of identify the key areas. So we have multiple jurisdictions here. Marion's cottage, jointly owned with her sister, who lived in the US, triggering cross-border probate and tax issues. There's an outdated will, last updated in 20 years ago, that did not account for 2 new grandchildren. A deceased beneficiary was on the list, and her most recent property purchase. Contentious beneficiaries, the estranged children. They're disputing the asset distribution and challenged the validity of the will. There were unsecured assets, valuable artwork that wasn't cataloged or insured, and jewelry that had been borrowed by a caregiver and needed to be recovered. There were tax implications. The estate faced significant capital gains tax on the cottage and income properties, along with the HST obligations for the small business that her husband's name was still on. The named executor, her eldest son, declined to be the executor due to the complexity and personal conflict. Therefore, a trust company was eventually appointed by the court. There were probate delays due to the legal disputes. There was missing paperwork, valuation delays, and so probate was actually delayed over 18 months. The real estate complications, a primary residence had a heritage designation, limiting renovation potential, and 1 income property was occupied by a tenant who refused to vacate. So that would be a lot in the complex estate settlement. Okay, so that just gives you an idea of the type of things that happen. So moving on, the key duties is getting in touch with trusts and benefits and doing their applications and addressing common challenges and timelines. So an 18-month delay in probate is significant. Of course, there's many benefits to working with a CEA, including having a broad understanding of estate matters, providing superior support, and can particularly be beneficial for executors who are unfamiliar with estate administration and those who are handling complex estates. Okay. The executor's role. This is a big one. So the executor's role, what I see, has changed dramatically from taxation to new family dynamics, divorce, remarry, sweeping legislative changes, and the risk of personal litigation create the perfect storm for the executor. Okay. So here are some of the key duties and responsibilities of the executor. Locate and review the will. You should really be, if you're the executor, you should really be informed of the location of the will. Is it with the lawyer? Is it within the house? Is it filed somewhere? I just hope that it's not sitting in the safety deposit box in the bank, because you won't be able to access the safety deposit box without the will. And if the will's in the box, then we've got a problem. You'll be arranging funeral and final expenses. One thing to know is for funeral arrangements, some have already set up their own final arrangements. Some have paid, some have not, but have set it up. So it's best to know from your testator, what were their wishes, who did they talk to, write it down, because you might not remember in 10 or 20 years. Okay. You have to obtain the death certificate. The death certificates are given to you by the funeral home. I would advise to have several copies, maybe 17, as everyone will require an original. You're going to apply for probate if it's required. If it's not required, usually a probate is not required if, for example, the husband dies and leaves everything to the wife. That's the right of survivorship. It's only when the wife passes away that the assets will need to be probated. Also, probate is not required when the estate assets are below $50,000 and there's no real estate involved. Okay, so you can sidestep that one. Identify and secure estate assets. Securing of the assets is critical. Change the locks on the house. Ensure that insurance coverage is still valid. Grab the jewelry box. Inspect the property often, and winterize or maintain the utilities to prevent any damage to the property. Okay. Distribute the estate to the beneficiaries, keep proper records, and of course, executors are expected to maintain clear records and provide accounting of the estate. If requested, I generally offer it immediately. And so just a note that I wanted to throw in as well is that there is executor insurance that you can purchase, and this will tie back into the personal litigation. There's a lot going on here. There's a lot of things that can go wrong. There's several companies that offer it. You probably won't need it if you're working with a lawyer, because their errors and omissions will cover any issues. Okay, so just a heads up on that. The role of the power of attorney. Okay, so there are two main types of power of attorneys that are recognized under Ontario law. There's a POA for personal care, and there's a POA for property, and each require written direction and really outlining the scope of the responsibilities. So POA for property. It's important to understand capacity, I think, is the first thing. Is the person physically, mentally, do they have capacity to operate their own property by themselves efficiently without getting scammed, without getting, it's just a number of nightmares. And I've got stories, but we won't go into it. So a POA is a legal instrument that allows the grantor to designate their attorney if and when they become mentally and or physically incapable. So for POA for property, your financial management, you're dealing with the accounts, investments, paying bills, debts, things like that. Property management, of course, real estate transactions should the house need to go up for sale because the person is going to go into a senior's home, then you're going to need to sign all of the documents. Other assets like vehicles, you may want to sell that. Personal property, digital assets. Property also entails legal and contractual matters, as I mentioned. But the signing of contracts or other agreements dealing with government bodies, you may want to or need to apply for benefits for, ODSP or something like that with CRA. So I wanted to point that out. The key duties for POA for personal care. Now, the attorney is tasked with making personal care decisions for the grantor. This might include daily living arrangements, health, medical treatments, medication, and a DNR. So my recommendation is have an honest and frank conversation with the grantor to understand their views on MAID, which is medical assisted in dying, DNR, do not resuscitate, and kind of throw at them what if scenarios. So what would happen if this, and do this while they're healthy and well and clear, and there's no ambiguity with what they want to see for themselves. Okay, so the POA for personal care will handle healthcare decisions, medical treatments, transfusions, palliative care, daily living and personal support. Do they want to stay at home with a PSW or a nurse? Or are they better served moving into an assisted living facility? And of course, always have respect for the grantor's wishes and values. So you're really guided by the grantor's instructions and their values and their personal beliefs. Yours are set aside. If the grantor wishes aren't very clear, then it's up to you to use your best judgment to act in their best interest, not your own interests. So that's why it's important to have that conversation and really get an understanding of who they are and what's in their heart. Okay. Here we go. Buying an estate property. Okay. When purchasing your agreement of purchase and sale should be carefully drafted to include typical buying conditions as well as tailored language for the estate and the executor. There's a lot of fraud out there. So you want to make sure that you have a conversation with the listing broker. And here are some questions that you might want to be asking. Has probate been granted? And if it's not, when was it submitted? Of course, we all know, did anyone die in the house? That's a stigma. How long has the property been vacant? This could be very important because there could be damage in the house if it's just kind of abandoned. And has the property been winterized and or maintained regularly? Okay. Your APS, agreement of purchase and sale, is formatted the same as most offers. However, you should include some special provisions. The executor / estate trustee, which is the same person, represents and warrants that they have the legal authority to sell the property. The executor shall provide the buyer a copy of the certificate of appointment of estate trustee within 5 days of acceptance of this offer. That certificate is formally known as probate. If probate has not been granted, insert a condition like giving extensions. So this is one that I use. This offer is conditional upon the seller obtaining the certificate of appointment of estate trustee with a will on or before, and you just select a date, If probate is not obtained by the probate deadline, the buyer agrees to grant an automatic extension of the closing date for a period of up to whatever days, 120, whatever you feel. You're going to have a conversation with your listing agent, and then, well, it's been submitted. They're saying maybe 60, 90 days we might get it. So that's where you're going to throw it in. So closing period for up to 90 days, for example, to allow for the completion of the probate process. If probate is not obtained by the end of the extension period, either party may terminate this agreement by written notice to the other, and all deposit monies shall be returned to the buyer in full without deduction. There's another clause that you can use as well that gives an automatic extension. If after the 90 days, it just keeps rolling over and over until probate is received. So you'd have to talk to your buyers about how they want to word it and how long they're comfortable waiting for probate. Of course, the buyer acknowledges that the property and its contents are being sold as is, we all know. And I would include, personally, a strong clause regarding cleaning, clearing of debris inside and out, include anything in the sheds, in the garage, under the deck, in the cold cellar. Sometimes these people have lived there for 50 years and family and friends come over to visit, and it's just normal to see that rusty rake by the side of the house. Throw the rake out, right? So those are the things that I personally look out for to make sure that it's easier for the buyer just to move in and do their own thing. Selling a property. Preparing an estate for property for listing requires a careful balance of legal, emotional, and practical steps. So hard. Sometimes it's so hard. So here's the key steps. Ensure that the executor has the legal authority to act. Obtain copies of the will, the death certificate, and the certificate of probate. Review the will or the court documents to make sure there's if there are any restrictions or special instructions. Check for multiple beneficiaries and confirm that they're all in agreement to sell the property. Secure the property, change the locks if necessary. I always do. Ensure that the insurance coverage is current and appropriate. So it's a discussion with the insurance company to say, hey, the place is vacant, we're putting it up for sale. Winterize and or maintain the utilities, heat, water, hydro to prevent damage. Organize and remove all the contents. You have to arrange appraisals on personal items if there's some high value items other than the house. You're going to clean and prepare for showing, as we do. Gather documents, as we do, recent tax bill, utility bills, warranties, manuals, whatever. I personally always get a pre-listing home inspection done with the report available to everybody. This will, for me, it disclose all pertinent information about the property, and that the executor may not live in the house, so they might not even be aware of what's happening in the property. As well, it shows for me, it shows good faith in selling, that you're the listing agent, you can be trusted to disclose everything that you know, and you've done as much as you can to get to the bottom of things. And then, of course, an aggressive pricing strategy with marketing keywords like estate, fixer-upper. I mean, there's a ton of them. So if that helps you there. Probate taxes. Probate tax is calculated on the total value of the deceased estate. Okay, very important. The probate taxes are paid to the Minister of Finance. That is provincial, the province of Ontario, by certified check, money order, or bank draft. Taxes are paid to the Superior Court of Justice when the executor applies for probate. So they go to the Superior Court with a money order or a certified check payable to the Minister of Finance in the amount that's appropriate. The probate taxes, as I said, is valued on the total assets of the deceased estate, not just on the value of the home. And generally, like, you're going to be taking into account their banking accounts, their investments, their, like, everything. If they have jewelry and you need it, get it appraised, like everything. However, you do not include jointly held assets or assets with named beneficiaries, like Joni gets the car. Okay. The estate pays the probate tax out of its assets and before any distribution to the beneficiaries. So everything has to be settled. The debts, the clearings, the final tax return, everything has to be settled before you distribute any monies to the beneficiaries. So it's really simple. Everybody gets intimidated by estate and tax calculations, but this is just so simple. The first 50,000 of the estate value is charged at a zero rate. Over 50,000 of the estate value is charged at a rate of $15 per thousand. So, for example, if the estate was worth 500,000, the first 50,000 is zero. From 450 all the way up, it's charged at 0.015. Therefore, your estate taxes are $6,750. I hope that that's clear. And then final thoughts. Planning is important. The best gift you can leave behind is clarity. Executor's responsibility is managing grief, relationships, complex decision with integrity and care. Don't go it alone. Lean on your professionals. Again, going back to making errors and estate and personal litigation. Take action. Don't wait. You really have to have conversations now. And handling an estate is never easy, but the right guidance, support, and planning, it can be manageable, respectful, and even healing. And that's all I have for you.
You say that's all you have, like you didn't just blow all over mine. That was an incredible amount of knowledge. I think even for those of us that have been through this or been through this process before, there was so much great info here. Like, thank you so much for jumping on this morning.
Thank you.
All right. Questions, everybody? I see Anna's hand up first. Anna, what do you have?
From my experience, like, what would you do, Valerie? Speaking about that, clause about cleaning and clearing the property and debris. However, it says clearly that property being sold as is where is. And so let's say the seller, they refuse to clear the property. What's your action?
Right. So it's the understanding that the property is being sold as is where is in terms of the mechanicals and appliances, the roof. It deals with the building, not the extra accessories that are littering the yard, the garage, things like that. Really, that'll be a tough negotiating point, but I think reason will take over. That if they don't want to do it, let me reduce the price, or let's hold back a certain amount for clearing, things like that. That might help you.
So basically, this listing agent should explain it clearly to the seller, right?
Yes. Oh, absolutely. Yeah.
I'm going to stick my nose in there for a second. If this does become a thing of contention and you reduce the price, or there's a tough negotiation, that is a wonderful closing gift as a buyer's agent. To send in a cleaner, to grab a dumpster. I know we've had several people on the team that have done this to make the experience wonderful for the new buyers on a property. So always, I agree, we start with the negotiations, and there's always a solution to everything, right?
Of course. Thank you for throwing that in.
I love that. Who else has questions this morning? I know we're digesting so much information, but throw your hand up, throw it in the chat here. Just while we have Valerie as a captive audience, let's pick her brain this morning. All right, Jake, what do you got?
I know you're going to say it depends on complexity, but in your experience, on average right now, how long is it taking from start to end on probate?
So again, probate is generally submitted as soon as you have all your ducks in a row. So that means that you're going to make sure that you have all of the monies accounted for, all of the assets valued, so it comes down to a money figure, and then submitted into the Superior Court. There was a huge backlog in Toronto Superior Court where probate was to get probate actually took anywhere from 8 months to a year. So the sooner that you can get things rolling and evaluated, the sooner you can get things happening in the court. Does that help?
It does, yes. Thank you.
Okay.
And just a clarification before I jump over to Anna, are you still seeing that backlog, Valerie, or is it starting to catch up a little bit?
It's starting to catch up here in Toronto. I'm not sure about York Region. It's probably 3 to 6 months now in Toronto. And funny enough, what's really backlogged is the family court with all the divorces. So that's interesting.
Anna, what is your question?
Val, is it true or false that in the event if the court find out that there is an offer on the property, they speed up the probate period?
You know, I'm not part of the court, Anna, and I can't say that would happen. I don't think it would happen. However, if you wanted to make it, you could still put the property on the market and you could still sell it and you could still have, you know, your agreement of purchase and sale. However, another clause will have to be inserted saying, it, you know, you can't transfer title without clear title. So without that probate, you can't do it. So that's when another clause comes in. Buyer acknowledges that probate has not been received, blah, blah, blah.
But I mean, also something to consider is if we're looking at, let's say, a 3 to 6 month for probate, if it's a very unique property, if it's something that we expect will have more time in the market, that again, it can be something useful to, let's get this listed, let's make sure we have the exposure and get all of that in. We can still have in that clause. And I think we know from experience on our team, it's not always the best situation for the seller clients to just wait until everything's buttoned up. It depends on what the client wants, right?
Yeah, for sure. Absolutely.
Love that. All right. Last call for questions. Anybody else before we set everybody free this morning? All right. Well,
great information. Yeah.
So good. So guys, we are recording this. So again, if your writing hand couldn't keep up with all the notes this morning, the recording will be blasting out. And again, thank you so much, Val. This was such information to put together and not just all of your knowledge, but this was, I just love this. And thank you so much for taking the time to share with us this morning.
Last question, Val, are you certified? Are you certified executor? No,
I'm sorry, can you say that again?
Are you certified? Because you said there are 15 people certified.
Yes. Yes.
Okay.
And I'm one of the 3 in York Region.
Wow.
I'm also certified in wills and estates with Osgood Law. So it was a law certification course strictly for lawyers. So I could do your will, not going to happen. Leave it to the professionals. Like I wouldn't want a lawyer selling my house. I'd rather have a realtor selling my house.
That just goes to all the knowledge that you're bringing to this and why you know all of the moving pieces to this. This was so great.
Thank you so much, everybody. I really appreciate the opportunity.
Thank you. And thank you to everybody joining in. Have a great rest of your day. And we will see you all for the next Feature Friday. Take care, everyone.
Have a great week and happy Father's Day.
Happy Father's Day, everyone.